Hello, this is Module 10, Pharmaceutical Patents, Subject Matter Exclusions. In this module, we will aim to understand the legislative history of Section 3 of the Patents Act and learn the statutory definitions and judicial interpretations of subject matter exclusions of pharmaceutical patents. For any invention to be granted a patent, the invention must satisfy three requirements: novelty, inventive step, and utility. However, this examination presupposes one very important step. It presumes that the innovation that the patent is being sought for is an invention. In 2002 and 2005, Section 3 of the Patents Act was amended to accommodate India's obligations as a TRIPS signatory. Article 27 of the TRIPS talks about patentable subject matter. Article 27 also discusses what member states may exclude from patentability. This, for example, could be diagnostic patents, therapeutic patents, and surgical patents for the treatment of humans or animals. Section 3 of the Patents Act, at least in theory, helps discern whether the subject matter of the innovation being claimed is patentable. The relevant parts of Section 3 that we will be discussing today are Section 3B, Section 3C, Section 3D, Section 3E, Section 3J, and Section 3P. First, Section 3B. Section 3B of the Patents Act excludes any invention whose use or exploitation is contrary to public order, morality, or prejudices animals, plants, or the environment. For instance, the Patent Office rejected an invention for a medicinal powder prepared from the remains of bodies a week after they were buried, on the basis that exhumation for profit was against public morality and public order. The Manual of Patent Office and Procedure also provides useful illustrations to indicate which inventions are patentable or barred under these provisions. This includes methods of adulteration of food or methods of counterfeiting notes. Next, Section 3C. Section 3C bars the patent eligibility of any living subject matter that occurs in nature. Given that subject matter under this provision is one deemed to be naturally occurring, it's worth underscoring that the Patents Act uses the term discovery rather than invention to describe such an application. We will also be discussing this section later in the module. Section 3D of the Patents Act is perhaps the most debated section in the Patents Act. The understanding, application, and import of Section 3D has been the focus of several litigation and patent office applications, and most recently was also decided in the Novartis case, which we will be discussing. Section 3D was implemented in India after much postponement to comply with the TRIPS obligations. This was to allay concerns that it would negatively impact the Indian generic industry by reducing market share and allowing multinational pharmaceutical innovator companies to monopolize the market with product patents, and also to allay concerns that the interests of the public would be compromised because of the high prices at which such patented medicines would be sold. In 2013, Novartis vs. the Union of India clarified and interpreted Section 3D. There are several conditions stated within Section 3D that must be satisfied before the provision is applied to bar a subject matter's patentability. We will be discussing each of them in turn. First, the term mere discovery. In Novartis, the court emphasized that owing to Section 3D's uniqueness, the provision ought to be viewed separate from the rest of the subsections in Section 3 that deal with patentability, and instead read in the context of its legislative history. According to the court, Section 3D was especially meant to be an extension of the definition invention as defined in Section 21J and Section 21JA of the Patents Act. Therefore, the Novartis judgment has deemed Section 3D, read with these two sections, Sections 21J and Sections 21JA of the Patents Act, as setting a higher invention threshold rather than the standard existing prior to the amendments in 2005. Thus, any analysis of pharmaceutical subject matter for novelty and inventive step for their patentability must be carried out with reference to Section 3D of the Patents Act. The section also discusses the phrase new form. It's a rather uncontroversial phrase when of the explanation to Section 3D. These new forms may be considered inventions under the Patents Act if they satisfy the criterion of enhanced efficacy over the known substance. It is, however, important to note that in a challenge on the grounds of Section 3D, the onus is on the challenger to first show how the claimed invention is a mere new form of a known substance. Next, the phrase known substance. The Novartis decision has clarified that a known substance appears to be any substance whose existence is not confidential and is known to the technical, commercial, or administrative personnel or members of the consuming public. Lastly, the most controversial phrase, enhancement of known efficacy. The known substance, which we have already defined above, is used as a reference point to determine whether the new form is an invention within the meaning of the Patents Act. The known substance must have a known efficacy. In Novartis, the Supreme Court held that efficacy in context of Section 3D can only be therapeutic efficacy. The court proceeded to construe therapeutic efficacy strictly and narrowly. It laid down the following rules. A mere change of form of properties inherent to the structure of known substance and the claimed invention will not meet the threshold of enhanced efficacy under Section 3D. Second, not all advantages or beneficial properties are relevant when considering the efficacy of a claimed invention through the lens of 3D. Notable illustrations of advantageous properties that would not meet the 3D standard include psychochemical properties, such as more beneficial flow properties, better thermodynamic stability, and lower hygroscopicity. Importantly, the court left the door open on whether increased bioavailability could result in enhanced efficacy. Bioavailability is the degree to which a drug or other substance becomes available to the target tissue after administration. This ends the discussion on Section 3D. We now move on to Section 3E. Section 3E characterizes a mere admixture as not being an invention within the meaning of the Patents Act. In other words, an invention is not patentable under Section 3E if the composition is an aggregation of the properties of its components without any synergistic or enhanced effect. Next, Section 3J. The Patents Act excludes all plants, animals, and their parts from patentability. The statutorily provided exception to this rule is that microorganisms and microbiological processes are patentable under the Patents Act. In 2013, the Patent Office issued guidelines for examination of biotechnology applications for patent that attempted to harmonize this statutory exception under 3J with Section 3C, already discussed above, of the Patents Act. The guidelines explain that the only logical interpretation from a conjunctive reading of these provisions is that modified microorganisms, which are distinct from naturally occurring microorganisms, are patentable under the Act. Next, we move on to Section 3P. In the context of pharmaceuticals, unlike the other subsections of this provision, Section 3P draws an important distinction between what can be protected under the patents regime and what is already known and entitled to protection under other realms of intellectual property laws. The undocumented traditional knowledge, which is extensive in India, creates a unique problem in the patent regime because most of this information is passed on generation to generation and is not widely known to the public. And some people opportunistically patent this information. Section 3P specifically bars the patentability of any invention known in the public domain as traditional knowledge. While any invention which is traditional knowledge cannot be patented, any value addition using traditional knowledge leading to a new process or product which is novel with inventive step and industrial applicability will be considered an invention under the Patents Act. To conclude this module, it's important to understand that Section 3 has been amended on several occasions by the legislature to ensure that the list of exclusions to patentable subject matter is exhaustive. Policy considerations have dictated the introduction of these subsections, and the effect of these policy considerations is perhaps felt most strongly in the pharmaceutical sector. Thus, carefully evaluating these existing statutory and precedential standards to determine what constitutes an invention under the Patents Act will enable patent applicants, challengers, and courts to more precisely define the contours of subject matter exclusions for pharmaceutical patents.